right, Article 7 is a very similar process to Article 10. And because this intervenor funding, and certainly in the pre-application phase, has never existed under Article 10. In the old Article 10, there was intervenor funding, but not in the pre-application phase. This new Article 10 has pre-application intervenor funding, and in looking at possible examples or previous decisions on how intervenor funding has been allocated, the most recent context for that has been in Article 7. Article 7 has a virtually identical regulatory framework as Article 10. I mean, the word for word, it's almost identical. So just throwing out some examples of what a previous administrative law judge has said with respect to intervenor funding applicants. This first one, there was a comprehensive proposal made, but the applicants left out some detail. So they provided an estimate of the total number of hours required for a project, and they provided an hourly rate. But they didn't break that down into subcomponent details. And so the presiding examiner or administrative law judge in that case said, essentially, I'm going to conditionally approve this application for intervenor funding. But before you're going to get any money, you've got to come back and provide me all this detail. So again, as I said before, detail is going to be critical in trying to put together an application that will be approved by the presiding examiner. Similarly, another Article 7 funding application for intervenor funding, a city application was rejected. The city had applied for money for legal review. They had in-house counsel, they had outside counsel, but they failed to distinguish as between what in-house counsel was going to do and what outside counsel was going to do. That was one issue. They had a contract with their outside counsel, but they didn't provide it to as part of their application. So that was another shortcoming. They had also asked for intervenor funding to defray internal employee costs for the city. Again, the application left out what was considered relevant information, such as the employee's job title, if there was an employment contract to that employee, a job description and responsibilities for that title and employee. Also, there was a lack of explanation regarding how the expenses and the intervenor funding would, essentially how that intervenor funding would defray the expenses of the municipality. Just two more examples. A town provided no contracts for the professional planner and land use attorney it wanted to hire for the intervenor funding. Again, the presiding examiner or administrative law judge in this case did not reject the application, but basically reserved decision and asked for additional information. A final example of a county asking for money just didn't indicate how many people it represented, what the interest was represented, as well as left out the contract for the experts it sought to hire. Again, the application wasn't rejected, but simply the applicant for intervenor funding was asked to come back with more information. There's going to be, in this pre-application phase, with respect to intervenor funding, a desire on the part of the presiding examiner, because it's actually written into the regulations, to get the awards for intervenor funding out the door quickly. So the more detail and the better job you can do in satisfying the regulatory criteria that are listed, the better off you will be, and the more likely it is that the intervenor funding application will be approved. After the preliminary scoping statement is filed, and no sooner than 90 days after that, an application can be filed. With the application, there's a second batch of intervenor funding that's going to be made available. It's $1,000 a megawatt, and we're probably talking in the neighborhood of $200,000 to $285,000 in that intervenor funding account. Very similar process to what will happen in the pre-application phase. Following the filing of an application, the presiding examiner will again issue a notice of availability of intervenor funding, and then applications are going to be due 30 days thereafter. If the intervenor funding is not all allocated in the first go-round of applications, the presiding examiner can set additional dates, additional a follow-on schedule for additional applications to be considered. Basically, we're looking at an identical process to what would occur during the pre-application intervenor funding process. The only difference is that in the pre-application phase, there's that window of 45 to 60 days where the presiding examiner is going to have to hold the pre-hearing conference and attempt to make awards for intervenor funding. In the application phase, there's not that 45 to 60 day requirement. The regulations simply require that it be held within a reasonable time after setting a hearing date. Whether you receive funding in the pre-application phase or the application phase or both, there will be reporting requirements. Essentially, there will be a necessity to provide a quarterly report to the presiding examiner, which also gets filed with the secretary of the Article 10 Siting Board, which will provide a detailed accounting of the money spent. Will show the results of any studies and activities conducted using intervenor funding, as well as articulate whether the purpose for awarding the funds has been achieved or progress toward the goal is being achieved and why further expenditures are warranted. So in summary, in thinking about what needs to go into an intervenor funding application, you need to identify the interest and the number of people impacted or interested in that interest. You need to identify the amount of funding sought. You need to identify, if possible, other resources that might be eligible to defray some of the costs, if not all of the costs of what you're seeking to undertake. You need to identify your expert and have their qualifications in place, and then details. You need to have the hourly rate, fee schedule with as much detail over and breakdown of that hourly rate and fee schedule, what those items are for. You need to identify how the services are going to add to the record. Copies of contracts, as I think I pointed out in the examples, I think they're really a prerequisite. If you don't have that copy of a contract with your expert or your outside counsel or your consultant, it's going to be a difficult hurdle to overcome. And then finally, if possible, if you can identify other groups looking to hire the same consultant or undertake the same activity that you're seeking to achieve. Again, if you can consolidate common interests it would make for a better intervenor funding application. So I think that's it.